Good evening, everyone. We will call the July 7th, 2022 special council meeting to order. If there are any citizens in the audience that would like to speak to items that are not on the agenda, we ask you to fill out a comment card. Please come forward to the podium, and we ask you to respectfully keep your comments to 3 minutes. Come on, Mr. McGuire, come on down. I'll let you fill out the comment card after, okay?
Okay, good. Okay, I just want to give you a progress report on how you've been doing. We could have a satanic ritual out on Cleveland Street, and you drop it from 15 people now. You got on a Friday night, you're trying to build in a capitalistic city, right? We can knock it down to 0, maybe 5 people, maybe. You know, there's no way you're going to win this MK Ultra routine you got here. Project Blue Book? Yeah, that's what it is, Project Blue Book. That's what it's called. It's called MK Ultra. Okay, it's already been outlawed. Why is it still going on? I don't understand. This is where I have a problem with the whole story here. You know, you're still facilitating a violation of the law. These people are brainwashed. They're literally putting it on at night now to try and hide them from us. So we can't see this. We can't see the old people there with their shoes cut in a groove because they've been walking so far. Both their shoulders are tapped together, right? They walk down the street together. Oh, that's perfect in a capitalistic society with little children walking around like zombies. They don't play with toys. They don't play with the playground. They don't do any of that stuff. They're not like us in that respect, okay? You know, these people are abused beyond belief. I sent you an email regarding paying these people off with the Aftermath Foundation. $100 million is just a down payment these people should have got for the punitive damage that was caused by this political process here. Not them. They didn't do it. We came in here, people knew this was going on. They kept saying no. Next thing you know, they're buying our political process. That freaking, the walk park for the public, perfect. It matches right with all the rest of it, right? You know, it's all the same thing, right? You know, it's ridiculous. The second you guys took that $100 million for this, everybody knew it was going to MK Ultra, to the Project Blue Book. It's got a million different names to it. I mean, it's appalling. It really is. It's appalling. And to see these elderly people working out there, you know, in this hot weather and stuff, you know, they'd stop at nothing. You know, they stop at nothing. Where's Shelley Miscavige? Can you guys bring us Shelley Miscavige? Wouldn't that be a great idea? When you were meeting with David Miscavige, ask him where his wife that's been missing for how many years now. I do not care if she's the cockroaches are eating her like Lisa McPherson. Bring her in here. These people went through necrophilia. Okay, with the wife and kids living in the car and with the husband.
This is a family show. So
this is a fact. Okay. It's a fact in England. So no, we want the wife back where we can see actually if she's alive, okay? Because we think she's been killed. That's what started part of this argument in the first place. Give us Shelley Miscavige and let these people go from this brainwashing that you have them on, okay?
Can you fill out the comment card, please, Mr. McGuire? Anyone else for citizens to be heard?
Good evening, Mr. Mayor, council members. Patrick Raftery, 42-year resident of the countryside area. I want to speak on an old subject that I've not been able to address with some comments and observations I have. And that is, I applaud the decision-making process with the unanimous selection of Ruth Eckerd Hall to manage and control the events at the new amphitheater that will be put in place. One of the things I think we should keep in mind as you go forward with those negotiations, and in fact, yes, the devil is in the details, is that we should have trust and flexibility as the critical elements of that negotiation. Trust in that this is a partnership with a common objective, successful operation and presentation of events as a win-win for both the city and Ruth Eckerd Hall. We are partners, we're not adversaries. There are many unknowns as this partnership moves forward. Therefore, we need to be flexible, as many details cannot be specified in the early stages of this activity or defined. As this is a new endeavor, unknowns will be present. Adjustments may be needed as circumstances change and events dictate that previous assumptions need to be corrected and adjusted. So in closing, as you go forward with these negotiations and the details that you need to have specified, I believe you should keep flexibility overshadowed by trust as paramount to the philosophy that you follow with respect to those negotiations. Thank you very much for your time.
Thank you, Mr. Rafferty. Anyone else for citizens to be heard? Okay.
Here comes Mr. You need a card?
If you can give it to Ms. Sprague. Thank you, Mr. Luba.
Back on June 6th, I filed a Florida public records request for some Clearwater police records, and I filed that with you, Mr. Margulies, because I knew they were going to screw it up, and they did. Now, beyond, the 9 Pelian principles of good policing, the police among us to be effective should also be our friends, relatives, and neighbors. Now, the subject of my open records request was Michael Ronald Wallach. He's a transplanted New Yorker. He also is a former pizza baker for nearly 7 years, so I guess a guy that works on a pizza oven for 7 years can't be all bad, and he probably makes some pretty good pizza. But does he fit those other 3 criteria? Is he your friend, Mr. Margulies? I don't know, Mr. Hibbard, is he your friend? Mr. Maxwell is not here, but I don't think he's his friend. Ms. Beckman, is Mr. Wallach your friend? You have pizza with him sometimes, you hang out? I don't believe any of you are related to Mr. Wallach, so that takes care of the second point. The most important one, I believe, is are they neighbors and do they belong, as a part of the neighborhood? And even though Mr. Wallach signed a promise to live in Pinellas County, he does not. He lives on Sumac Court in Trinity, which is in Pasco County. Now, beyond the promise and any changes that anybody can say about the rules, Mr. Wallach is just basically an outside hired gun. He has no real ties to this community. He has no real connections other than his job. He's a bit of an inbred Clearwater cop who chooses not to be a member of this community. And I think that's a poor choice for assistant police chief. I've spoken to Mr. Wallach. He tells the same things as if from a script. He will continue to be a Clearwater police defender of bad practices. No way is he going to be an advocate for change. I believe there was an opportunity for some change when that position became open. That was not taken, and I'm very disappointed in that. We have to have police officers, especially the leaders of our police department, that are committed to the community. And when you just come in from out county and stomp around and do your job, that doesn't do it for me.
Thank you. I do not believe, though, as a requirement that our deputy chiefs have to live in the city of Clearwater, and we've even had chiefs that didn't live in the city. So, anyone else for citizens to be heard before I close it? Okay. Mr. Jennings, before we start, anything you want to add?
Nothing other than I just want to thank Mr. Margolis. He has worked incredibly hard over the last 10 days or so, whatever it's been.
Seems like a month.
Yeah, has worked the weekends and everything, and so, David, I just wanted to point that out, that we're in your debt, and I also want to thank the Gotham Group and their representatives for working collaboratively with us as well.
So tonight, we're gonna be dealing with item 4.1. That's solely what we're working on tonight, which is really the referendum question that will be before us on November 8th. There are still ongoing negotiations with the development agreement, which we will be examining and discussing at a future meeting, correct, Mr. Margolis?
Yes, sir.
Okay. So item 4.1 is call for an election on November 8th, 2022, to present a referendum question to the city electors, amending the charter of the city to allow the redevelopment and sale of two certain unoccupied properties in the downtown core and pass ordinance 9597-22 on first reading. I will turn it over to you from here.
Thank you, Mayor. Once council voted on June 16th to begin negotiations with Gotham, as Mr. Jennings said, it's been quite a busy past few weeks, on not only on our side, but also, as Mr. Jennings said, on the Gotham side as well, and the D'Annunzio team. Doing this in record time, especially through Independence Day weekend, is not easy. But I'm pleased to say that we've made a lot of progress. I feel good about the direction that we're heading. As the mayor said, the item that's on tonight's agenda is specifically dealing with the ordinance that will be put before voters, asking voters to consider whether they will allow an amendment to the city charter, which will in turn allow us to ratify all of the terms of the deal. So, what does that ordinance actually say? That ordinance, which has been shared with council, I will go ahead and read it by title right now, if that's okay with council. But I expect that by the end of this, if there are adjustments and tweaks that council makes to the language, we will most likely need a motion to reset the first reading for July 21st. And that's okay. Ms. Call has confirmed with the supervisor of elections that if we make some tweaks or adjustments this evening, or rewrite the entire thing this evening, that's okay, because we can reset a first reading for July 21st. Then, after the adjusted or revised version gets passed on July 21st, a second reading will be set for August 4th. Those are the normal council meetings. As I said, Ms. Call had confirmed, gesture to her empty seat, but just trust me, she did, with the supervisor of elections, that in fact, they just need 90 days notice. So as long as council passes this ordinance on second reading, August 4th, we will still make the November ballot, which is the direction that council has given. So to that end, the title as currently presented to council for 9597-22 is as follows. An ordinance of the city of Clearwater, Florida, calling for an election to be held on November 8, 2022, submitting to the city electors a proposed amendment to the city charter to allow the city to negotiate the redevelopment and sale of certain unoccupied downtown property in the downtown core for the purpose of creating a vibrant, mixed-use development consisting of multifamily housing, hotel, and commercial space, including restaurant dining, cafes, and event space, activating the area adjacent to Coachman Park. That is our current title of the ordinance. Everything that follows in the body of this ordinance are the amendments to the city charter themselves, meaning that the underlying text that is shown would actually be the new language that will be in the city charter if voters approve the ballot question in November. The main question for council is really toward the bottom of the ordinance, which includes the summary or explanatory statement that will be presented to voters on the ballot. Even though there's a ton of things that go into this behind the scenes, and even though, Ms. Cole and I are working nonstop on the development agreement, on a purchase sale agreement, on all these different things, voters will ultimately need a fair and accurate summary of at least the charter amendments so that voters know what we're asking them to consider for the future of downtown. All of the other documents will all be discussed publicly at council, as the mayor said. So all of this is going to come out in public discourse over the next few weeks. But for right now, what's most important this evening, with the time constraints that we are under, is for council to agree upon the explanatory statement at the bottom of the ordinance. If nothing else, that is really the most crucial, and really, I would say, only crucial matter to address this evening. So the language that's before you is language that has been proposed by the city attorney's office. I've gotten input from council members. I've gotten input from the city staff and the city manager. I've gotten input from Gotham because this is going to affect them as well. However, council is free this evening to make as many changes as you like. It's not going to hurt my feelings one bit, so please feel free to mark this up, change it, make any changes you like, but whatever changes you make have to be made now so that we can lock in the language.
In 75 words.
In 75 words and,
Or
and,
less.
and thank you for reminding me of that, Mayor. So not only in 75 words, well, one slight reprieve is that hyphenated words can count as one. So if there's a hyphenated word that's a reasonably hyphenated word, I think we could count that as one. But yes, to the mayor's point, 75 words is all we get. From my perspective in protecting the city, what's most important substantively in these 75 words is that we have to inform and educate voters as to what changes we're actually making in the charter itself. So in other words, we need to tell them what the charter says today versus what it is that we're asking them to consider for the future. If we communicate that in a fair and transparent way, then we will be fine from a legal perspective.
Questions for Mr. Margolis? Councilman, Vice Mayor Beckman.
Okay, so I understand that it's important that tonight our ultimate task is to okay the 70-some words, right? On page 3 at the bottom.
5.
Pardon?
5.
75 words? Yes, okay. However, all right, so I only have one question about the 75 words, and it goes back to the ordinance that's written in all caps, and it's the phrase consisting of multifamily housing, comma, hotel. Can housing mean both condos and apartments, and do we want to limit it to just apartments?
That's a great question. So multifamily housing, as that term is typically used, potentially could include both condos and apartments. However, my understanding, and thankfully Ms. Cole is here to speak to this, but I believe that Gotham's business model to which they are fully committed is apartments exclusively. I do not believe there are any plans for condo conversion, condo construction, or anything to that effect. I see Ms. Cole shaking her head vociferously in the negative. So based on those conversations with Gotham and based on the uses that council has contemplated in the body of the ordinance, which as I said will amend the city charter itself, we go into some more detail about what those multifamily housing will look like. Most importantly, from my perspective, the city charter, if amended by our voters, will say that these properties, meaning the City Hall site and a portion of the former Harborview site, must have, and this is now quoting from the current language, it must be multifamily housing that remains available for rent to the general public. And so that would seem to align pretty closely with apartment usage only. If this language is approved by council and approved by voters, that will operate as a use restriction that is durable. So that will essentially include any sort of conversion or use in the future which would not allow the property to be used for rent to the general public. Now, the charter could be revisited in the future, of course, but it's a pretty durable restriction in there. So if council is concerned to ensure that this remains apartments, I feel pretty confident that these provisions will ensure that these remain apartments.
Well, why not just change the word to apartments and be, as firm as possible?
We certainly could. The term multifamily housing has some pretty specific technical definitions in our code, so that's why it was actually a more precise word to use. But if council would like to change the word multifamily housing to apartments, especially in the title of the ordinance, certainly council could do that.
Councilmember Albritton.
Yeah, and I agree because one of the things that I think is going to be important to our citizens when going to the poll and voting this referendum is knowing that they're going to be apartments and not condos, because we don't want secondary housing on the bluff with people buying a condo and being here 2 months out of the year where apartments, people are gonna be here and pretty much live here in the apartments. So I think that going through this, that was something that, with the vice mayor, that I kind of think is important to make sure the public understands that right in the 75 words. I don't know if they're gonna get into really the meat of the ordinance when they go to vote, but this part of it is on the ballot, and I think if you let them know it's apartments versus condos, that may be an important
I
word.
think there's always gonna be some people that really dive into the details and read everything. But I think we should be as specific as we can within the constraints of the 75 words. And I understand that multifamily technically has definitions within our code, but I don't know that people really care about that. And the clearer we can be with the language, for one-stop shop, to me, I would agree. That was a change I also made in one of the versions that I came up with. And the only other thing I wanted to add in here, and can still keep the word count down, is not only the 158 key hotel rental housing, but restaurant as well. It is in the body of the charter change, but one of the things that I think is critically important is I think citizens need to understand, first of all, in the RFP, we did not want condominiums because we understand that oftentimes the condominiums are not occupied year-round. We have a lot of people in condos throughout Clearwater. It's great, they can afford it, and they could go up north when it gets too darn hot, which I wish I could do right now. But we're here. And so we wanted rental because we want people that are going to be there basically 365 days a year who are going to be frequenting restaurants and retail and everything else and adding to vibrancy. The other thing we wanted was a hotel. Those are not necessarily the highest and best use on those properties. Condos probably are. But we're trying to revitalize downtown. So I think the more specific we can be about the amenities, first of all, that are going to be built, but are also going to be available to all of our citizens on a daily basis, then they can see what's in it for me. And I think that's critically important in a referendum. Not only the tax revenue that's going to accrue, the additional activity, but what am I going to be able to do on these properties that the city has owned? And now I can go to restaurants, I can eat, overlook, imagine Clearwater, take my family when they come in from out of town and show them this dynamite place that we have downtown. And so I think that ought to be included, and I just did a copy with spacing, as I think an English teacher would tell you to do, so you can put edits in there, at least.
Very nice.
That's what my high school teacher told me. And it's one word short. Do you want to give one to Mr. Jennings?
Oh, thank you.
Yeah, Mr. Margolis, sorry.
Do you want to put restaurants? Because we can have more
Yeah,
than
it can be
one.
plural. Should be plural, you're right.
Yeah.
Can't we shorten it to just 600 apartments rather than units of rental housing?
That's a good idea. I mean, if we need more words somewhere.
You want a copy? It's very, can you pass that down to Nicole? I asked Ms. Brigg to put the original document in a Word document so she can put it up on the screen. And there it is.
We could put, maybe we could add, if we have some extra words, if we do approximately 600 apartments, 158 key hotel, restaurants, entertainment and retail amenities. I mean, You know, I mean, there's that little entertainment venue or possibly, you know, things like that. I don't know.
I'm
'Cause
fine with
entertainment
that.
is-
The more descriptive
yeah.
we can be on the public amenities, I think the better off we are.
I do too.
Because many people will walk in and this is the only thing they're gonna read. Are you okay with taking out the, just saying 600 apartments?
I think that's fine. I mean, the purpose of, I mean, let me say it this way. The courts understand and sympathize with the challenge that local governments face, because on one hand, we want to put as much information out there to voters as possible so people know what they're voting on, but at the same time, the legislature has constrained us to 75 words. And there's only so much you can say about a complex deal in 75 words. I think apartments is a great word because I think everyone in common language understands what that means. I do want to just make one comment, and not to move on from that topic, but also, of course, related to the final verbiage here. One of the issues that I know that's important to our development partners, and I agree with them, is the phrase 158 key hotel. Because we are so early in the process, it's possible there may be small deviations in that. If the final number ends up at 159 or 157 or things like that, it's probably best not to have a hard number. Or if we do have a hard number and we add the word approximately, that would be fine as well, as long as we're still in the 75 words. The mayor indicated, I think, that this is 74. So if this is 74, and if we were to add another word approximately after the word housing, that would, I believe, address the concern that Gotham and I have discussed.
Does that include the word entertainment?
I think we've got enough words then. I mean, because if we're taking away 4 units of rental housing, we're gonna add apartments, entertainment, and approximately.
So can you take out units of rental housing and replace that with apartments, Nicole?
Let me delete the underlying title because that's adding to our words.
And that would be consistent with approximate number of apartments, approximate number.
So on approximate, you know, because I know we're gonna get the question when we're out in the public. Do we want to not, I mean, I'm gonna ask the applicants to come up, so. Is there a concern that you would want more, or that you would want less? And approximate, to me, means you're only gonna deviate by how many units?
5.
I would say, as the attorney for the city, I would feel comfortable with a 10% deviation, either plus or minus. If I had to defend that in court, let me say, I would feel comfortable 10% plus or minus deviation.
And can that then be put into the body? Outside of the question itself?
Sure. We could potentially add a provision in the body. Right now, in the body, I've kept it a little bit more general than that. But if, to the point, Mayor, if there's a desire to communicate to residents that it will not be any bigger or more dense than this, for example, that certainly could be added this evening to the body of the charter itself. But to your point, I definitely would want, with D'Annunzio and Gotham here, for them to weigh in on that so we don't accidentally write ourselves into an impossible situation.
Ms. Cole?
Good evening, Mayor, council members. Katie Cole with Hill Ward Henderson, representing the developer. Thank you for the opportunity, and Mr. Margolis correctly said we did express concern over the 158 key hotel and providing flexibility to that number. To address one question, the max number is 600 and 158. That's what's been advertised for the development agreement under the city's code and process. That's what would be drafted in the development agreement. And to increase any density or intensity on the site, which is not memorialized in the development agreement, would require an amendment to that development agreement. That said, as the mayor pointed out, the language in the actual charter amendment does not memorialize those numbers. It's just attempting to properly reflect what the project is. So we are comfortable with the word approximately. To Mr. Margollis's point, I believe with staff and through the DRC process, we've been talking about a minimum maximum of the apartments between 500 to 600 or 525 to 600, just because it hasn't been designed yet. And so the ultimate goal is the 600, but once we do parking and do unit counts and spread out, there may be in a building that size some fluctuation. So 10% might not be enough when at the apartment, but certainly a 10% reduction at the hotel would be more than enough. And candidly, I mean, we don't expect it to be any less. We expect these numbers, but to the mayor's point, we wouldn't want to mislead the voters that there is a difference. So having some equivocal language before both the housing units and the hotel would be important to the developer. We also think it's important, instead of either in addition to or instead of amenities, to clarify the commercial spaces and restaurant uses. Amenities could be implied to be specific to the housing and hotel use, and so having that opened up to include restaurant and commercial spaces. I think, nitpick language, but instead of who will create, you can lose another word by saying to create or to develop. So there's some room to play there, but the language you all are speaking about to both add the flexibility to the unit count, be clear on apartments is fine, and ensure that the communication is that there are commercial spaces there.
Well, I think we want to give certainty to people that it's not going to get bigger, and that's obviously already in the agreement, but I also want to make certain that it doesn't shrink to the point where we don't have the economic impact.
Absolutely.
And if that's, spelled out in the document, I'm fine with that rather than in the question, obviously, but I think that's necessary.
The development agreement, as Ms. Cole said, will specify minimum numbers of apartments. We're still figuring out exactly what that number looks like, but there will be a minimum number of apartments there. As far as the hotel, if council would like to specify a minimum number of keys, then that certainly is a point that we could negotiate with the developers.
Okay.
Any other questions for us at the time?
No, but don't go far.
I will be right here.
Okay. So what were the other additions, Vice Mayor, that you wanted to add?
Well, I think we're good. I mean, I think I feel good with, the language on the ballot.
What's our word count, Nicole?
This is at 72.
Okay.
Now, this is directly from the ordinance, not is that what you had passed out as what is in the ordinance?
No, it had a deviation.
Oh.
It had rental. It's fine.
So we were eliminating units of rental housing, substituting apartments, and putting in approximately after the apartments. Is that correct?
An approximate 158 key hotel. I mean, is that how it would read?
Do you want it for both the rental units and the hotel, Mr. Margolis?
That would be best if we could fit the words, for sure. I mean, that's something that Ms. Cole and I have discussed rather extensively. I know that's a strong ask on their side. Honestly, I'm not quite as concerned about it as they are, but I understand their concerns. So if possible, I would prefer to have that word.
So instead of the A, you can say and.
And approximately 158 key hotel.
Well, the approximately then applies to both the apartments and the hotel.
Oh, and, yeah, okay. And then we have to do it twice.
So after the apartments, make it and instead of A.
Are we adding entertainment in there?
Come on up. I can't read lips, so.
Sorry to be the grammar police, but if we're
Yeah.
going to use approximately as compounded, did you want to use it twice or compounded? We just need to remove the comma.
Yes.
And then and then
And
remove the
approximate.
second approximately then.
Yeah,
Takes a-
I love doing this on the dais.
Right? That's okay, I have my sheet with lots of word counts on it,
Yeah.
so.
And what was the other change that you were recommending?
Oh, and retail amenities, it could say approximately 600 apartments and 158 key hotel, comma, retail, comma, commercial, comma, or instead of commercial, restaurants, amenities.
Yeah, I want
To
restaurants
add
in there.
restaurant language,
We
so,
had
and
entertainment.
then add,
Entertainment you mentioned?
have
Right.
a series of listed
Okay.
uses.
So restaurants is easy with just adding the S, but entertainment and commercial amenities, is that?
I think I'll defer to Ms. Clayton, who's there with respect to uses, and Mr. Margolis, who's in. Retail and restaurant probably
Retail,
encompasses
comma,
all of the
restaurant.
commercial uses that
Okay,
exist, because otherwise you're moving to other offices.
Yeah, I think Ms. Clayton and I are nodding at each other. I think we agree.
You're welcome to come up too, Gene. Come on in, the water's fine.
Yeah.
Restaurants, plural.
And amenities.
Is there do you want to come after restaurants?
Commercial amenities.
Depends who likes an Oxford comma.
And commercial amenities?
Hey, give us a word count.
Do we still want the?
This is 73.
does entertainment
It
fall
is.
under commercial? Does entertainment fall under commercial amenities?
Well, we're not putting in commercial amenities, are
Oh,
we?
I thought you wanted
we were
commercial.
replacing that with restaurants, retail, and entertainment.
Okay.
Go ahead.
Well, yeah.
We were talking about
The
if there was
cultural.
a cultural use or public space, because certainly in our proposal, we had provided the convention
Yes.
space as well as the other. So Mr. Behar was suggesting cultural.
But are you guaranteeing that you're going to do
Well,
cultural?
that's the question. And again, this is just a description of how the charter's being amended. It's not the list of everything that may be the option in the development agreement. So I think I would be more comfortable excluding cultural here and referring to it more aspirationally in the development agreement, if that's acceptable. But I don't, in my opinion, Mr. Margolis, I don't think that this description doesn't preclude that use necessarily. It just is a descriptive as to what's happening, and we want that to be the most communicative.
I agree. I mean, this is one of those areas where I can give a very technical lawyer answer, but there's also kind of the realities of how we communicate with voters. So on one hand, as phrased, this is simply encompassing the entire universe of possible uses, but not obligating us to have any particular use in there. I would certainly agree with all of that legally, but I fear, politically, I think it's important for voters probably to know here, more or less, what they can expect to get.
I think so too.
Yeah, they need fair and full disclosure.
I mean, when you said event space is aspirational, I mean, I think
Oh,
the
no, the
event
event
space is
it-
gonna be there.
Oh, yes.
And so that needs to be communicated
The
in some way.
cultural is
But-
aspirational.
It's how it's described, whether the open spaces are used by a museum or by, there are a lot of different uses that go into that planned space, so.
But public amenities, would that cover it?
I would think an event space, it's interesting how we look at what a definition of, I would think an event space would fall under a cultural type of an amenity, but you think it's different, an event space?
I do.
I mean,
I
you can
do.
have an art display, you can have dance, you
Or
can
they
have a
cannot.
lecture.
Or they can just have symposiums and lectures and not
Yeah.
have any, you know what I mean? So I don't,
Well, yeah,
I perceive it as a difference.
Convention or weddings,
Yeah.
and you've talked about even having an aquarium component, right? Can be pretty far afield.
Well, you know, and maybe second part of my questions, I like that we're wordsmithing this, but another tangent of my questions is right above it when Mr. Margolis refers to this body, which is under B. The agreements described in subparagraph A must include at a minimum the following enforceable provisions. And that's where I'm like, okay, why aren't I seeing some more things? And so how long can that be? You know, because would an enforceable provision be an event space? So I've got, why no language about the presence of a hotel, overnight accommodations, event space, the minimums we are expecting with, you know, restaurants, bars, cafes, retail was one comment. And then another one was, as to both sites, there's no mention of a duration of an agreement. And that's like profoundly important. And where does that go? I know it's part of the development agreement that you're working on, but to me, if we're going to mention something as, you know, we're going to prohibit any development of self-storage facilities and light assembly here, why not articulate how long this development agreement is going to last? Because earlier, I mean, I have some indication it's like, you know, 20 years or something. I mean, are we going to be as specific? Because I'm telling you, that's what residents are going to want to know.
But there's a difference between the charter and the development agreement.
Yeah.
That's ultimately the question for council is, and that's the delicate balance here, is how much detail to put in the charter itself. There is no word limit, so council could certainly add any number of different provisions. But many of those provisions, at least in my opinion, are better handled through the development agreement process because they get pretty far into the details. Once something gets codified in the charter, we are now bound by that more or less for all time until the charter is amended. And I do have some concern, particularly given the ambitious time frame in which we're doing this, that we may accidentally write ourselves into a place where we find out that the development agreement is not going to be compatible with the charter itself. And so that's the dilemma. And so I would encourage council to, although you can add anything you like in here, to be judicious in the big picture of things that we're putting in here, because it will constrain the city's ability and this council's ability to approve a development agreement with the developer.
But it'll constrain, but it'll also protect. You can look at it two different ways, right?
Absolutely. And so that's why, at least with what I've presented here, the numbers 2, 3, 4, 5, the Roman numerals, 1 through 5, at least in my opinion, are the core things that we must codify more or less for all time in the charter, so that voters know at a core level what we are committed to in the long term and what this city is, in for the long haul, and when it comes to these properties. So I do think that it is appropriate to include some of those issues, as the Vice Mayor said, to protect our citizens and so the citizens know what they're getting. However, again, it's a delicate balance. The more we put in there, the more it's going to tie council's hands. We are going through this in very quick fashion. I fear that if we get too specific, it may preclude council from negotiating an agreement that's otherwise advantageous to our citizens.
Well, I'm going to lean on your counsel for that personally. And I know a lot of the provisions that you want in the development agreement, which I think add the protections that we need. I'm fine with this language. We are so limited that I don't know that there's, much more we can alter. I see you stirring, Ms. Cole.
We were just reflecting on the cultural uses question, and I think amenities can be implied under the code that the multifamily will have residential amenities and the hotel will have its own. So perhaps you could replace the word amenities with and cultural uses to give notice that that's an intended and permitted use. But That would be a suggestion. 'Cause certainly it would be the developer's intent to incorporate that as we move forward. I don't have an active word count, so I wasn't counting words to
I
know
think
if
we
that
were at
works for you.
73.
Did we end up ending entertainment? Oh, no. Are we still?
So that bumped it to 74, right? Eliminating amenities and putting cultural uses.
How's everyone feel about that?
I'm good.
Do you want entertainment in there?
I'd
I
like,
think retail
I'd like
restaurants.
to have entertainment
Okay,
if we can get it in there.
so take out the amenities.
Cultural spaces.
Uses.
Uses.
Comma, entertainment, just comma, entertainment.
Or just put it right after restaurant?
Entertainment should be after
Oh,
restaurants.
yeah.
Or retail, or wherever you want to place it.
Put it after retail. God, that's 2 hours.
Entertainment.
That's 75.
There you go.
Any comments, Mr. Jennings?
No, I think it does capture the full opportunity of the proposal, and obviously the opportunity for the city. It clearly defines what the uses will be. The only question I have is, I know Councilmember Albritton, we spoke recently about using the word harbor view, as to whether there may be some confusion. So I did want to just kind of raise that, because you had mentioned that to me.
Yeah, I think people, when you say Harbor View, they think of the entire building that Harbor View used to encompass. And actually, what the hotel's going to take up is a portion of Harbor View.
And portion is in there. And a portion of the former Harbor View sites.
Okay, did we put that in?
It's there.
Yeah.
Okay.
I agree with you. That's a really good point, because, they would consider it the Harbor View parking lot and everything else, which obviously this site is not that big. And a lot of Imagine Clearwater is on there. Don't take it out.
No, I was just
You're highlighting it? Okay. Thought you were gonna ace it. Vice Mayor, you had your hand up.
Yeah, I'm okay with that language.
The original didn't have portion.
I think it's fine. I don't know if, I'm still a little concerned about some of the body, maybe adding a little bit more to the body of the charter.
So tonight we're only voting on the question, and the body can we still tweak the body or no? Or is it today?
Tonight,
Okay.
any material amendments, it's okay to change grammar or syntax, little things later on, but certainly any substantive provisions, especially if there's a desire to add more restrictions in the charter, should definitely be made this evening.
Well, what are your thoughts about adding, a Roman numeral, another addition about duration of the agreement,
I think that would be fine. I do want to point out that state law caps a development agreement at 30 years, so there's no universe in which it could persist longer than that. Our own code caps currently development agreements at 20 years, and so if we were to amend the charter to say up to 30 years, we will probably have to come back later and amend our own code to conform to the new charter amendment. But if there's a desire for council to do that, that would certainly be permissible. But 30 years under any circumstance is going to be the cap. Now, I do want to point out that a development agreement can be extended by agreement of the parties, and oftentimes that does happen. I have provisions in our current draft which say that the development agreement may very well, and the parties reserve the right to extend it as appropriate. I wouldn't be surprised at all if this one ends up being extended for a variety of different reasons. But there are limits, so that way a future council has the ability to revisit this topic.
Well, I would like to get the development agreement to 30, so I'm happy to amend our ordinance to increase from 20 to 30.
I certainly at this point, I mean, I haven't had that conversation with Ms. Cole, so I don't know what their thoughts are on that. I mean,
We're going to take a 10-minute recess, and I'm going to let you talk to them. Good evening. We'll reconvene the special council meeting. Mr. Margolis.
Thank you, Mayor. I did just meet with Ms. Cole, Mr. D'Annunzio. She's been speaking with her clients. What we were just talking through for both council's benefit and for the public benefit is making sure a couple things. Number one, whatever duration we put in the city charter is compatible with state law so that we don't accidentally violate state law. Number two, to make sure that it is something that that is not going to cause problems that were unforeseen or unexpected, particularly things that we don't think about as much on the city side, like their financing and issues that can affect them. Because certainly up until now, Ms. Cole and I have been discussing an agreement of 10 to 20 years. I certainly planned on going for 20 because I think that's reasonable, but 20 years has been the cap in our code up until this point. So with that being the case, Ms. Cole can speak more to it, but I believe at the risk of speaking for her and her clients, an agreement with an initial term of 30 years would be something that they are amenable to. Does not seem like that would cause any major heartburn, and so if that's something we'd like to incorporate in the charter, I believe that would not cause any problems based on what we know right now in terms of the development agreement. So the way we'd want to phrase that, if we want to put it as a 30-year term rather than as a 20 or less term, we would want to add another subsection, as the Vice Mayor said, and we could probably put, I'll either do it as a subsection 6, or I'll have to look at that momentarily, but think about exactly where we're going to put it. But wherever we put it, whether it's in B or whether it's a subsection 6, it will have to specify that the initial term of the development agreement will be for 30 years relating to this property. So that would not preclude any sort of future amendment. It would not preclude a future extension. Who knows what's going to happen 30 years from now. But it will say an initial term of 30 years. I do think if we're going to say that, we should also be very specific and point out that the term of the 30-year agreement must comply with the terms of the development agreement itself, as well as the other restrictions in this charter. And that way we're all on the same page as to what the expectations actually are. In other words, I don't want this new provision to accidentally be interpreted as either negating or overriding either other provisions in the city charter or any provisions in the development agreement itself. So as long as we're careful in how we draft it, I believe we have an agreement on that.
And you are amenable to that? I'm seeing head shaking. Okay. Ms. Clayton, can you come up real quick? The reason we have a bunch of professionals is to get their opinions on things. And during the recess, Ms. Clayton and I were talking, and she had an opinion on the word entertainment. And is it a duplication somewhat with cultural? And also, does it connote something that we may not want?
Right, that was the question.
Do you want to just give some more detail about that?
Well, I think that pretty much says it in looking at the plans that have been submitted and talking to the applicants about what they're proposing. I was trying to get what would be entertainment in their uses that is not of a cultural nature. And so I think I would really rely on them to give you the firm answer. And I guess when I heard the word entertainment, I don't want people to think that this is Party Central or, something that you're really not intending and that the developer is not intending to build. So I don't know, maybe Katie could clarify if, that's something I shouldn't be concerned about or not.
Right. Or Mr. Behar, whoever wants to dive in on this one.
Certainly, Katie Cole. We do not want to mislead the public with respect to entertainment, because there is, while entertainment in the generic sense, meaning a band at the beer garden or a musical group, would obviously be part of the programming of this area and to activate it, I would not want anyone to get the impression that the word entertainment was something more than just general programming. So I think that any of those uses are incorporated in the retail, restaurant, and cultural description, any ancillary entertainment uses. So it totally, but defer to you all on that.
Questions?
Well,
Vice Mayor?
we toured that development in Tampa that had a small playhouse incorporated in theirs. You know, would that fall under entertainment if there were a community
Cultural.
theater there? Okay.
What I think that we really don't want to open up is that we're gonna have nightclubs lined up all down on the bluff, so I kind of agree with that, that people are gonna think that that may be going a little bit too far, and that we can probably eliminate it.
Well, we want this to coexist with, you know, the residential. So I think that's why we have these professionals. I would agree that we probably ought to strike entertainment, and that the cultural covers a lot of what is anticipated.
I'd agree.
Is everyone comfortable with that?
Sure.
Yes, it could be misleading, but, yeah.
Somebody in the audience even said, does that mean you could have a strip club?
Yeah.
And we don't allow strip clubs in Clearwater, so I just want to make that clear. There's one grandfathered in and one's in the county. Somebody said, well, how do you know all that? And I don't firsthand, I just want everyone to know. And I think my wife is watching this program, so.
Okay, so we're
So
striking
you can
here.
take out entertainment.
74.
We could put 600 snazzy apartments.
Snazzy, yes.
Snazzy apartments.
So
Deluxe apartments.
any other alterations?
I don't have alterations for that, but I still want to go back to the body if we're, you know, if we, I don't, you know, we're kind of back and forth, but
Okay, I'm putting this to bed, although I'm gonna open it up to citizens, to make comments in a minute. But let's go back to the body of the charter. And are you doing this on the fly, Mr. Margolis, or?
I am, and so that is, of course, always a precarious situation to be in all honesty, to counsel. It's kind of like performing heart surgery on the fly, but that's why we're going to read it out loud. That's why everyone in the public, as well as the developers and the council, get to hear exactly what's going to be stated, and we'll pretty much read it verbatim if there is a desire to do that. So based on what I've heard as far as potential conversation, I have come up with a proposal for potential language subject to criticism and review. If I may?
Yes.
As to subsection B in the ordinance that we're talking about here, which again is part of the city charter itself, I would propose adding 2 new subsections after Roman numeral 5. So in other words, a subsection Roman numeral 6 and a Roman numeral 7. Roman numeral 6, based on my initial drafting, would say as follows: a development agreement with an initial term of 30 years, period. That would be something simple, it's straightforward. The reason I drafted it that way is because earlier on in the ordinance, and specifically in subsection A, we are talking about both development agreements and purchase agreements. And so I want to make it clear that the purchase agreement has nothing to do with a duration of 30 years. I'm sure that the developers would appreciate that as well. So a development agreement with an initial term of 30 years is Roman numeral 6 that I proposed. Roman numeral 7 would say a provision in the development agreement. That's what we get for editing on the fly. A provision in the development agreement requiring that the terms of the development agreement shall be subject to the provisions in this charter.
Read it one more time.
Sure. A provision in the development agreement requiring that the terms of the development agreement shall be subject to the provisions in this charter. Now, I do want to point out that we would never negotiate or enter into a development agreement that is inconsistent with the city charter. However, if this provides additional security or if it provides additional comfort for residents, then I see nothing wrong with adding that language.
Have you typed that?
Yeah, I've got the ordinance and I can type that into it if you'd like to see.
Can you do it
Yeah.
so that it can be put up on the screen for,
Where's the,
David, when
Thank
you, when you put number 6, a development agreement with an initial term of 30 years, does that mean it's not to be altered? It can't be, it's,
Under state law, as well as our own code, a development agreement can be altered through a statutory process. And it's a, fairly elaborate process. If the amendments are anything more than just minor in nature, they need to more or less start from scratch. And so more or
right
less,
there
it's going
under
to
B?
go to,
No, I'm talking to Nicole. Go ahead.
it will more or less go through the same process that council went through initially. I'm not talking about the referendum, but certainly it will have to be reviewed not only by staff, but also by the Community Development Board for a first public hearing, and then this council for a second public hearing. So there's always a possibility of amendment in the future. And the truth is, I think we would always want
it's a
that.
safe thing, right? in case-
Right, because
yeah,
who knows,
Right.
15 years from now or 20 years from now, what the future is going to hold. But I do think it's important for residents to know that this document that we're negotiating is pretty durable. It takes quite a bit to make significant amendments to it, and nothing can be done under the cover of darkness. When we're talking about significant amendments to a development agreement, as I said, they go through that public hearing process, so there's no secrets.
I think number 6, especially the way you wrote it, it will be addressing many of the residents' concerns. I think. The clarity in the way that you stated it and the addition of number 6, I think, is important.
As I mentioned earlier, and this is a minor point that we can certainly deal with after the fact, but if council does approve these changes, and if voters approve these changes, we will need to come back before council to amend our own community development code to conform to these changes. Not a problem, just want to let council know that that's something we'll have to do after the referendum if it passes.
Is that what you have, Mr. Margolis?
Testing my nearsightedness here.
Can you enlarge it, Nicole? I have a little bit different. Maybe I typed it
Look
wrong.
here, Dave.
Oh, maybe if
Right
I
here.
look at the, perfect. Thank you very much. It's much easier to look behind me instead of look in front of me.
And it's in terms. You've got an N.
You want me to spell?
Sorry.
Without the paragraph markers, I assume that
Oh, I'm sorry.
So I would just say the word "a" before the word development agreement. So we say a development agreement.
Up here on
Yeah,
6.
with an initial term of 30 years, and I would probably also spell out the word 30, so that nobody thinks it's a typo or anything like that.
What was the thing you said before the 30 years?
Yeah, 30, then if we put in parentheses, 30. So if that portion moves up to Roman numeral 6, or what'll be proposed as Roman numeral 6, I think that would potentially be okay. As far as Roman numeral 7 is concerned,
That's
I mean, that's kind of the essence of it, but that is kind of the effect of it. However, the phrasing that I suggested, and it could be tweaked easily, is just to say a provision in the development agreement we say a provision in the development agreement requiring the agreement to comply with all terms in this charter, or something like
Yeah,
that.
you had requiring that the terms of the development agreement shall be subject to the provisions in this charter.
However we phrase it, I think it'll get us to the same place, so barring some strong objection.
Ms. Clayton?
I'm sorry to interject. I just want to be clear that when we bring the development agreement for approval here over the next few weeks, that how will we address the fact that that agreement is obligated to be 20 years under the code?
I think the way that we will address that, that's something I've just thought of, but I think that we would already planned on saying that the development agreement itself is contingent upon the approval at referendum of these charter changes, so it will not go into effect. It will not have an effective date until after the referendum.
And by then, we can change
Okay.
our
Sorry,
ordinance.
If you could just help me finish where I messed up here. With all terms, requiring the agreement to comply with all terms.
Could say all terms in this charter, or something like that. I mean, I wouldn't,
Do you want me to read what you said the first time?
Sure, and I have that as well,
Oh,
and we could
okay.
use that instead. I'm just throwing out ideas for
Yeah.
conversation. I think that ultimately, this is a question of what does council feel comfortable communicating to voters? So, yeah, please don't feel obligated to use my language. We can say it however council wants to say it.
Yeah, but I want to use your language.
It's fine.
That's why we're paying you. Are you okay with this language?
Yes, in Romanet 7, because we talk about agreements lowercase in sub B, I would just suggest using development agreement twice. A provision in the development agreement requiring that agreement or the development.
You had it twice when he first said it.
Yeah,
Provision in the development agreement requiring that the terms of the development agreement.
yeah. And then I also share the concern that Mrs. Clayton expressed about the code. Obviously, one of the terms to adopt a development agreement is that it's consistent with the land development code. So I haven't looked at law recently about whether the deferred effective date bridges that gap, but the development agreement is required by law and under your code to have a recital that we're consistent with the land development code. So that would be my only other hesitation. I agree with Mr. Margolis that from a practical standpoint, the agreement's not going to be effective until, everything has to happen at the time of the referendum, but I would not want this to create a situation that obviated the approvals that we seek in a couple weeks. I've been trying to determine a solution to that because we recognize that this is important for 30 years instead of 20. But I just felt the need to express my hesitation on that based on the recitals, and at the time you're actually having your public hearings and approving it, one of the recitals in the agreement is that it complies with your land development code. So
It certainly is a little bit of a dilemma, but I am optimistic that we can work through that, just based on how we tweak the effective dates, how we begin this process potentially of processing a text amendment, and how we just work on the timing of those. I do believe there are solutions for that. If this is the direction council would like to go, I'm confident we can make it happen, although admittedly, it's a challenge, but we can solve it.
Any other comments?
Going back to
Yeah.
the body. So going back to the body part, the second one, as to the former city hall site, multifamily housing that remains available for rent to the general public, do we want to specify or need to specify any percentage of that, that's available for rent to the public, like 95% of it, 90% of it? Is that necessary here, or is that part of a development agreement enough?
It is currently something that I've been negotiating with Ms. Cole as part of the development agreement. One thing we have to be careful of, although we can put a percentage in there, they may have things like corporate housing or other opportunities that are potentially legitimate economic drivers for the city and could attract businesses here in the city. And so I want to be careful not to preclude uses that are actually reasonable and legitimate uses. But at the same time, as the mayor has pointed out, we all know that we want residents, right? We want primary residents. So I have been negotiating that with Ms. Cole. The exact percentages will be in the development agreement.
Which will be good for hopefully 30 years at least, right? And then
That's the plan.
renewable. And then the number 3, as to both sites, thoughtful and measurable sustainability provisions for environmental stewardship. To me, I mean, I like it. I don't see any meat in it. I don't see any measurables. It's like it's vague and aspirational. I mean, why is it there, and can we get more teeth into it?
Well, I would say as to why it's there, I mean, I do think certainly it's important for our voters to know that we as a city are committed to sustainability, not only in general, but I think on these sites in particular, as we get so close to the waterfront.
Right.
This is, to me, an example of trying to balance the need for showing our commitment to citizens, which is why there's a requirement that there be measurable sustainability provisions and why there's that level of specificity. And we're baking it into the charter itself, so it's going to be a durable requirement, even if there's a future council, or even if there's amendments 30 years from now, they will still have to comply with this requirement. On the other hand, if we add too much specificity, it could have some significant impact on our ability to negotiate the development agreement, and so that's where council has to make that decision in terms of how specific does council want to get in the charter itself, with the recognition or the acknowledgement that it will handcuff our ability to potentially reach a development agreement that's satisfactory to everyone, and that's the tough balancing act.
But in the RFP, this body agreed to go ahead and make silver lead the standard that we were requiring. That the components would be in the projects. So that's something we did back before the first RFP and it went out. And I think we're going to, memorialize that in the development agreement.
That's what I understand too. So I mean, I didn't know why it was here, or if we can make this stronger and say, and again, continued improvements as technology advances or whatever, because certainly in our development agreement, we're pushing for things like EV charging and solar and all that, and sustainable plants. But once they do that, as it's built and we have a grand opening, then are they going to check this off and say it's done? I'm done. I've done your sustainable things. I've got measurable sustainable provisions here, and I'm done. Or is it going to be in effect through 30 years with, as we can see, improvements along the way?
It's a great question. It's going to depend on exactly what we negotiate with them. Some types of sustainability measures are really designed as one-time, certain design features into the building, for example, whereas other sustainability features are more on the operations or maintenance side. So it's really going to get into the details of exactly what provisions we negotiate with them.
I don't think we can put in our charter, though, things that aren't even imagined as far as technologies down the road and expect somebody to comply with those as they come to the forefront. In my opinion, that's what the market does. They're going to have tenants that are going to demand certain things if they want to make the property marketable because they're competing with other properties around the region, and those will be changes that they will make as it's necessary based upon technology, efficiency, and ultimately demand.
What if we added, as to both sites, the word ongoing? As to both sites, ongoing, thoughtful, and measurable sustainability provisions, you know, or, I don't know, it's just, I mean, I don't know, I just wonder why it's, I mean,
That's a decision for council. I mean, the word ongoing certainly would strengthen it. There's no doubt about that. It would also.
and it's still not super concrete. It's like up to interpretation. What does ongoing mean? Every 5 years, every 10 years, we do something? But at least it communicates continued.
I would have to probably, with the mayor's permission, invite Ms. Cole to speak to that. I mean, because as I said, some of those issues on the sustainability side are more of the one-time things, and some really are the ongoing. And so at this point, because we're in the process of discussing exactly what sustainability measures will be in there, I would probably have to defer to the Gotham and Denunzio team as to the type of provisions they're envisioning and what commitments they can make in that regard as of right now.
We're fine with the word ongoing. I mean, to the mayor's point, the vast majority of sustainability requirements are upon construction, but there are certainly some things that, as a developer, as tenants turn over or improvements are made, that could be considered. So I don't think that's an obligation to make changes on a regular basis. It's an obligation to be thoughtful about your stewardship on an ongoing basis, and certainly they are that, so.
You know, or maybe like 15 years from now, if we don't have any, if there aren't changes or improvements, maybe a citizen can come forward and say, hey, you know, in our charter, it says it's supposed to be ongoing, and we haven't seen any improvements in 15 years, and what can we do? I mean,
Would you buy a property? I mean, swear.
Yeah.
Let me ask you something. If your townhouse out on Sand Key, you bought it with a restriction that you had to make a specific improvement when somebody came along and told you, would you buy it? Because I sure as heck wouldn't.
Well, you know, the only reason I maybe not, I don't know, I'd have to give it a little more thought, but I'm just wondering why it's here. You know, I want it to be a real meaningful statement. If it's going to be here, I want it to be meaningful, you know.
And respectfully, I think this is maybe just my personal opinion about a charter as compared to a regulation or an ordinance, right? So this is the constitution of the city. This is saying that these sites will have thoughtful and measurable sustainability provisions. And that is the overarching policy goal of the council. My personal decision is that policy statements like this shouldn't include such minutia and details, but certainly voters and elected officials make other decisions, so I don't know that it's necessary. I think that this sets forth the goals of the city in an overarching way that says it's extremely important to the city to have environmentally sustainable measures, and that you expect that these agreements and these projects to do that. So I do think that the way it's drafted by Mr. McGaullis is exactly reflective of that overarching goal and the policies that you all have adopted to date through Green Print and other things. So I don't know that it's a necessary word or change, but.
But you guys would be okay with ongoing? Ongoing isn't a
I
big deal?
just got our, a no, we would not like ongoing from our colleagues who are watching online who weren't able to Zoom in.
I'm fine with it the way it is.
Yeah.
I don't know, maybe I'm oversimplifying it, but I think of this as a syllabus. It doesn't encompass everything, it's not very detailed, but it's something, it's a syllabus, it's a simplified way of looking at it. And I'm not too wrapped around adding too much words, because I don't think we're restrained to it. I don't think we're, you know what I mean? I think it's just a general depiction of what the agreement is, and I don't think we should go into the minutia of this. Not having ongoing, I don't think is going to jeopardize their willingness to maintain that building and respond to the sustainability issues, I think. Because the market's going to demand that, the tenants are. But I look at this in a very simplified way as general idea of where we're going, rather than the exact thing. I don't know, what do you think, David?
I mean, I drafted it, so I'm a little bit biased. But, it is funny. I mean, I think as attorneys, Ms. Cole and I probably see it the same way, even though we're on opposite sides of the aisle. I do think that, in law school, we're often taught that the Constitution really is just, an overarching document. The fear that lawyers have on both sides of the aisle is the fear that we put something in our Constitution or in our city charter that has unforeseen consequences that we are then not able to improve at a future date. We are doing this particular deal that has a lot of implications for the future of downtown. It's very, very important we get it right. And so I do have the concern that if it is too specific in the city charter, it may preclude this council from approving a development agreement that may very well have all the things that you value and that you care about, but if we just didn't say it quite the right way, or we accidentally put a word in there that restricted us in an unexpected way, we could actually jeopardize the entire project or the future of downtown. And so that is the fear. Whereas with the development agreement, like with any law or regulation, as Ms. Cole said, we know that honestly, if we mess it up, it can be amended later. If we make mistakes, we know that we're working quickly, but Ms. Cole and I know that it can be brought back to this body later on for reconsideration of changes.
Well, and I think we look at our charter too often, unfortunately, every 5 years. Tampa does it every 20, which may not be enough, but I just don't think it belongs in the charter. I don't even know that I would agree with having all of this language, but I think I can live with it. I don't want to alter it any further. I'm going to open it up to the public for any comments on this item. Is there anyone from the public that would like to speak to this? Have you filled out a card, Mr. Johnson?
Not yet, but I will. Thank you very much.
Thank you.
I hadn't really expected to say anything, but as the discussion has gone on, I found myself looking at the whereases. And I know that that's not your main focus, but since it's in your document. Going back to the HRNA Citizens Plan, they talked about the importance of an active edge on the park as being important to draw people into the park, but also to draw people from the park into downtown. And the gentleman from Gotham, when he was here before, was talking about the importance of that interaction both ways. And I don't see that really in these whereases. I think it would be important to add a whereas that the elements that you're considering putting in the development agreement really implement a lot of that active edge. And so by adding that to the whereases, you would articulate to the citizens that this is just part of implementing the citizens' plan and ensuring that the park is going to be active. And in that regard, the 8th whereas, where it says to stimulate downtown redevelopment for the benefit of all Clearwater residents, I think you could, I don't know how to do the active edge thing, but I think you could say something like the Clearwater City Council would like to complement and activate Coachman Park for all Clearwater residents, because you want to get people, the residents, to the park and get them hanging out in downtown. Or another way would be to provide benefit for all Clearwater residents that enhances and further activates Coachman Park. I mean, or that that does that and stimulates downtown vitality. I don't know that we're trying to stimulate redevelopment downtown. We want an active, vibrant downtown, not just tearing down old buildings and putting up new buildings. I don't have any specific language, but I'm throwing out some thoughts here that I think would be important for the ultimate goal of getting citizens to vote yes on this. Thank you.
Thank you. I think the fourth whereas doesn't spell it out, but it talks about potential complementary redevelopment, to Coachman Park. So if that's something that we wanted to accentuate, it could be added there as well. Anyone else from the public to speak to this?
Filled out a card earlier today, Patrick Raftery once
Thank you,
again.
sir.
In my previous comments, I've used the two words trust and flexibility. Perhaps flexibility might be substituted for compromise. And I think we need to keep that in mind as we go through some of the details here. What concerns me is that the desire for specificity might cause this to be in jeopardy, as Mr. Margolis has pointed out. And therefore, that trust and compromise or flexibility needs to come into play. I would encourage you to keep that in mind as you go forward with the details. If you trust, you're not going to have a fear of having to protect or a fear of being taken advantage of. You trust the other party to understand where you're coming from, you understand where they're coming from, and you'll come to an agreement. So I would ask you to keep that in mind as you go forward. Limit the specificity as much as you can to allow the developer and yourself to come to an agreement. The most important thing I think we need to keep in mind, which I'm certain is in the back of everybody's mind, is the audience that we're talking about is not here present. It's the voters. They're going to vote on this referendum in November. Their 75 words has got to put in front of them as simply as possible what we're attempting to do, and the detail will be in some of these provisions that you're talking about. There are some people that will be against this from the start. They were against Imagine Clearwater. We went through that exercise. They're not going to change for some words or some ideas that you might be presenting here. That group is going to stay the way they are. They may have objections if Jesus Christ himself came down here and made some provisions to us. There's a second group that I include myself in that has been in favor of Imagine Clearwater from the start, enthusiastic about it, and it's the last opportunity we have to develop Clearwater and make it attractive to many people. Therefore, I'm in favor of this. The group that you're really talking about is those that are maybe in the middle, that are looking at both sides. They're uncertain. And that's the group that I think we need to make sure understands what we're doing, and supported by members of council out in the public, presenting this to them as to why this is the right thing to do and why that vote should be yes. Because if we fail to do that, then this will be a project that died. I just want to bring that to your attention. I'm sure it's in the back of your minds. This is a great discussion. This is a great challenge. There's a bigger one coming in November to get the people to vote for it. So I encourage you to keep that in mind, because I'm hoping you will be out there selling this to the people and enlisting citizens like myself to help sell it as well, because we're close to getting it over the goal line, but we're not quite there yet. Thank you very much.
Thank you, Mr. Rafferty.
Can I respond?
Sure.
Thanks. So I like to consider myself a flexible person, enjoy compromising and shaping things. I'm also a trusting person. I'm also a person who comes from a family of attorneys who practice various types of law. And, this is the public's money. This is the public's property. And I'm, up here functioning as a guardian of that and working in their best interest. And I tend to operate on trust and verify. And I love a handshake and all that and trust people, but, I want it in writing. And so there are some important things that I think that are important to voters, that are important to me. And when we have vague statements that don't have measurable descriptors, it can be interpreted in multiple ways. And so I get the trust and being flexible, but I also, there's a whole lot of value in having something in writing, and when you have to go to court or litigate something. So I just,
I don't think anybody's debating getting things in writing, Vice Mayor. I think what's being debated here is, should it be in the charter or should it be in the development agreement? And my personal opinion from being up here for a long time is, it doesn't belong in the charter. It belongs in the development agreement. And, I just think that's critically important that we separate the two. I'm fine with putting things in the development agreement. That's where they should be. That is the contract. This, as was said, is our Constitution. There's some weird things in our charter that probably shouldn't be there, but they're there and we live with them. And if we want to change them, it has to go to referendum. We've tried to do that, and at times the citizens have approved it, and at times they've said, no, we're going to leave it in the charter. So.
well, and along those lines then, why would number 4 be in the charter and not in a development agreement? As to both sites' project timelines that offer reasonable assurance of timely completion, I mean, that's certainly a real finite charter amendment that only applies to as this thing is being developed. Why wouldn't that just be in the development agreement? Why does it have to be in the charter?
It doesn't have to be, but the feedback that I've gotten from each member of this council is that project timelines are very important. And that given the overarching importance that I have heard from each of you as to compliance with project timelines, combined with the fact that I think this concept is straightforward enough that it can go in the charter, and general enough that we can still negotiate the specifics, I felt like this was a good opportunity to show our citizens that we are committed to getting this done candidly while we're all still alive. And so that was my commitment, so that's why I have that in here. But I'm glad you asked that question, because even in this with number 4, I kept it general enough that we can negotiate exactly what those timelines are. If we were to become, say, more specific here, we could easily destroy the entire thing accidentally, because we're still figuring out, and I think Ms. Cole and her client are still figuring out what those timelines exactly are going to be as we go through this complex project. So I guess to answer your question, Vice Mayor, the standard for me in my proposal for these provisions has been how important is it to council as a body, based on the feedback that I get from each of you? Is it something that is going to be important to voters, and that they're going to want to see this as a durable, lasting provision that restricts future councils in what they can do? And does it preserve enough flexibility where this body and our future elected officials can make decisions that are in the city's best interest based on our needs at the time? So for me, those are the 3 standards. But as I said, I mean, it will not in any way hurt my feelings if council makes amendments to these, tightens them, loosens them. Ultimately, I am very sensitive to the fact that our voters have trusted each of you to make these decisions and put matters before them for recommendation because they trust your judgment. And, I'm proud, just if I can get the soapbox for a second, I'm proud to serve with each of you because each of you represent diverse views within our community. And so, if you guys feel as a body that we should either have more things, fewer things, our people trust each of you to make those decisions.
On to Scott, resident of Clearwater. I just want to kind of back to what you said, Mr. Albritton, about the park being just a part of the Harborview site. If I understood correctly, does number 1 speak to that? And does it say, because in the beginning, you all put in the 75 words, a portion. So does that need to go in number 1 as well?
Well, it's in the actual question.
So it doesn't need to go?
No.
Yeah, okay.
I don't believe, Mr. Margolis.
Well, we've actually, we're very careful, I think, to put the word portion in there because of exactly what Councilmember Albritton has brought up. Even though Mr. Jennings and I were not here in those years when it was operational, I too have heard the feedback that when we start saying things like the harbor view and we start using that in colloquial language, I have heard both from elected officials and from members of the public that that means different things in people's mind as to the exact parcel of land that, or the boundaries of the land that we're talking about. So the way it has been drafted right now says that we are only talking about a portion of the land, and we actually put that in a few different places. Number one, in the charter itself, if it's approved by voters, says that we will be entering into a purchase and development agreement for a portion of this parcel identification number. So we put it there for one. And then second, because I know that issue is so important, we will also have that on the ballot question, if council approves it as currently drafted, where it says, shall the city charter be amended to allow the city, instead of selling the vacant city hall and a portion of the former Harbor View site. Now, so that is the goal, but the, I mean, that's all I got.
I do think the question, though, is whether we should add a portion. Nicole, if you were to go back to the...
It's there, a portion of it's on the ballot.
Not on that, on this.
On the charter.
As the site of the former Harbor View Center.
I mean, I would say that if we were going to edit that, my suggestion would be to say, as to the former Harbor View site, just to bring it in line with subparagraph A.
I was just going to say that exact same thing, that subparagraph A, little 2, it defines the portion of as the former Harbor View site, and so I think in subparagraph B, little 1, it should
Site.
reflect the same, capital F,
Yep.
Harbor View, and then use the word site. And then likewise, when discussing the City Hall site in little I, it's defined as Old City Hall parcel. So it should be defined in the same manner.
I agree.
Can I just ask a humor me question? Because I can't reach out to the developers while you guys are negotiating, but I have a question. Can you just explain, and I know we've made a decision, we don't want this word, but what's the objection to not putting ongoing?
I think exactly as the mayor expressed, it's somewhat, and as Mr. Margolis said, it's somewhat of a slippery slope. Having something that is not defined, it is unknown because sustainability measures are constantly evolving and changing. There is not a current code in the city to reference what would be appropriate check-ins or looks or numbers. To your point, Councilwoman Beckman, a citizen could at any time in the duration of this time period perhaps file litigation on their own terms of what they view as ongoing, even though that perhaps was never the intention of you all or the developer or defined in the development agreement. I can probably go on and come up with more slippery slope arguments, but I think the mayor recapped it and Mr. Margolis did as well. But that would be our hesitation as well, as just the unknown definition of that word.
Thanks.
Anyone else from the public to speak to this? Okay, I'm going to close public comment. Any other thoughts? Is there any interest in adding some language about the active edge or something? to that effect?
I think that's a good idea. I mean, if it's not too much to add to the whereas part, I mean, is that
I'd put it under the
complicated?
fourth, personally, at the end of that, and I just came up with, and the intention is to create activation between Imagine Clearwater, the identified properties, and the downtown core.
Yeah, I think that's good. Covers both ways.
Mayor, that may be a bit for,
I'll read it back to you, I just want to see if anyone,
Where would you put
That's
that under? I missed that.
I put at the end of the fourth whereas.
Okay.
That's the one that says Clearwater residents amend the city charter.
To adopt Imagine Clearwater Plan for Coachman Park, which identified potential complementary redevelopment, which I think is important, of certain downtown core properties adjacent to Coachman Park. And the intention is to create activation between Imagine Clearwater, the identified properties, and the downtown core. And then I guess you have to add another "and" to roll into the other whereas. You're better
There's
off
always-
up there,
yeah.
Mr. Margolis.
yeah.
You want me to read it one more time?
And identified properties in downtown?
Core.
And the intention is to create activation between Imagine Clearwater, the identified properties, and the downtown core.
No.
I don't know if people know what an active edge is, so I'd rather use a little bit more general language.
I like it.
What?
No.
The identified properties and the downtown core. Yep. That's what I said, yes. How is everyone with that?
Good.
Okay with that? All right. What other questions or comments, or does somebody want to make a motion?
I make a motion to approve the ordinance as amended.
Well, I would suggest, given the importance of,
Enormity of this?
Yes.
You want to read the whole thing?
The whole thing?
perhaps given the enormity of this, we should go ahead and, why don't we just summarize the changes? I'll read through what I have. Let's make sure our council agrees in concept, and then we can make motion section by section. I think Ms. Sprague will appreciate that, Ms. Call will appreciate that, and the Supervisor of Elections will appreciate that as well. So, first change that I have that council would like to make, it is actually in the title of the ordinance when we're talking about multifamily housing. Did council want to change that particular use of multifamily housing in the title of the ordinance to say apartments instead of multifamily housing? And was there an interest in doing that?
I think
we
it's
should.
appropriate.
We want it to be as
Consistency.
specific as possible.
If that's the desire of council, then I would recommend that a council member make a motion to amend the title of ordinance 9597-22 to replace the phrase multifamily housing with the word apartments.
So moved.
Second. All in favor? Aye. Opposed? Unanimous. Do you have something to?
I just procedurally, will we be re-advertising in the entirety then?
We will.
We won't rely upon just a third read. Thank you.
Yes. We've discussed that with both the city clerk as well as the supervisor of elections.
Okay.
So just for everyone's benefit, even though we will be resetting and re-advertising for a new first reading, I will, just for everyone's benefit, both on the dais and in the public, reread the title now as amended by council. So the title as amended by council of ordinance number 9597-22 is as follows. An ordinance of the City of Clearwater, Florida, calling for an election to be held on November 8th of 2022, submitting to the city electors a proposed amendment to the city charter to allow the city to negotiate the redevelopment and sale of certain unoccupied downtown property in the downtown core for the purpose of creating a vibrant, mixed-use development consisting of apartments, hotel, and commercial space, including restaurant dining, cafes, and event space activating the area adjacent to Coachman Park. So that is the title of the ordinance as currently set by council. The next change that I have in my notes is in the fourth whereas clause, which was the issue we were just discussing. And so the way that I wrote it down is to add a phrase at the end of the fourth whereas clause, in other words, after Coachman Park, and that new phrase says as follows, quote, "And the intention is to create activation between Imagine Clearwater, the identified properties, and the downtown core." Does that align with council's expectation for it? If that aligns, then I would recommend that a council member make a motion to approve that change to the ordinance.
So moved.
Second.
Any questions? All in favor?
Aye.
Opposed? Unanimous. Number next.
The next one I have up is a question of whether there was, and I did not hear any, so I wanted to make sure, any desire while looking at the whereas clauses to modify the whereas clause that is 4 sections down that says, whereas the Clearwater City Council would like to stimulate downtown redevelopment. That was what prompted Mr. Johnson's comments, which then prompted council to amend the previous whereas clause. Is there any desire to change this whereas clause talking about stimulating downtown redevelopment?
I think we've accomplished what was asked. Is everyone fine with that? Okay.
Okay. The next one I have is going to be in the body itself. So moving on to the subsection 8, which will be a brand new section in the city charter, if approved by voters.
Hey,
And if we
excuse me.
look,
Sorry to interrupt. That last whereas on the first page, do we have to change that multifamily housing to apartments or to align with what it is in the title or not?
we do not have to.
Okay.
However, if council would like to do so,
Well,
we could do so if
Let's
council
be
wishes.
consistent.
Yeah.
It's the last whereas on page 1.
The third line. So do you want me to make a motion to remove the multifamily housing phrase and replace it with apartments?
Please.
I make
So
a
moved.
motion. So moved, yeah.
Do I have a second?
Second.
Any discussion? Okay. It's the very last whereas Gotham Property Acquisitions LLC,
On the first page.
and it's on the third line.
Mayor, if I may.
Yes.
So the next one is, oh, they
We passed it.
passed it.
Who made it?
No,
Motion by Councilmember Bunker, seconded by Councilmember Tejeda.
Not sure there was a vote, though.
Was unanimous.
Yeah, I called it. Yep.
Oh, you did? Oh.
I thought I made the motion because I read it. Never mind, it doesn't matter.
All in favor?
Aye.
Aye. Mr. Margolis.
Thank you. So, looking at the new provisions in the city charter, it is subsection 8, which, as I said, is a new provision. And specifically looking in subsection 8B, which is part of the new provision, council has discussed adding 2 additional Roman numerals, which will be Roman numeral 6 and Roman numeral 7. Roman numeral 6, well, I'll read them both together, but Roman numeral 6 says, a development agreement with an initial term of 30 years. That's 30. Roman numeral 7, if approved by council, will add new language saying a provision in the development agreement requiring that the terms of the development agreement shall be subject to the provisions in this charter.
Any questions on that? Do I have a motion?
So moved.
Second.
What you just read is not what.
Do we,
Okay, then that's why this is exactly why we're talking about this. So, it's literally why we're talking about this. So, we need to ensure that the motion that passes aligns with the language that everyone either has agreed to or that has been voted upon. So,
Requiring the development agreement to comply.
does council have a preference as to which way we would like to phrase it? As Ms. Sprague pointed out on the board, it's proposed in Roman numeral 7 as saying it would require the development agreement to comply with all terms in this charter. That's one way to say it. Another way, which was the first time I said it, was requirement in the development agreement that it is subject to the provisions in this charter.
I like subject to the provisions. I mean, just-
I'm fine either way.
And does it need to be a small Roman numeral? Because does it fall under the B, like tabbed in, or, right?
It will have to
When-
be. It will have
Whenever
to
you
be
do it?
tabbed, yeah,
Okay.
it will be tabbed in.
Yes, yeah. Editing is not, so I'm sorry.
So do you want to talk about subject to versus comply? In your opinion, are they synonymous?
I think they're synonymous.
Okay. Do you want to make a motion to
Sure.
use subject?
Do you want me to do both 6 and 7
Yes.
in one?
That would be fine. I mean, I think there's clearly acclamation for council to approve both, so I don't have any problem doing it as one motion. But I do want to make sure that Ms. Sprague is following along with
But
what
that
council.
needs to be changed then.
Yes, so. One
So-
more time for me. Thank you.
Sure.
Oh,
So-
that's fine.
So you can say a provision in the development agreement requiring the development agreement to be subject to the provisions in this charter, if that aligns with the vice mayor's.
Okay.
Is that okay?
Yep. So I make a motion to add 2 new subsections. Subsection 6 that reads a development agreement with an initial term of 30 years. And subsection 7, a provision in the development agreement requiring the development agreement to be subject to the provisions in this charter.
second.
Any questions or comments? All in favor?
Aye.
Opposed? Unanimous.
The next one that I wrote down is in the ballot question itself, in the explanatory statement. The most important, well, there's a couple ones in here, but one of them that was talked about, I don't know if there's council has a preference. Ms. Cole pointed out that there's a phrase after Gotham Property Acquisitions and the D'Annunzio Group, and that phrase says, quote, "who will create." She recommended that it say, to create or something worse to that effect. If there's interest from council in modifying the phrase, "who will create," it could be changed to be "to construct." Whatever language council is comfortable with, I think will accomplish the same goal.
I would say to construct.
Yeah, I'm okay with
That's fine. I mean, you can get rid of the who, right?
Sure.
To construct?
Yes. Down.
In the
Oh, and a question.
So we've eliminated 3 words. And added 2.
Are we just saying 600 apartments? Is that what it says?
approximately.
To create approximately.
correct.
You want that changed to create?
To construct.
To construct. Or will construct. Shouldn't it be will?
Yeah, I would say will.
No,
Will
No,
construct.
it can't be nil.
no, to construct.
To sell the properties to, and
If I may, Mr.
Sure.
Mayor, I
That's
think
why they call it making sausage.
it is, that's what I said to Mr. Behar, isn't he glad he's here to see this? I think to develop is the most appropriate term.
Develop.
Okay,
your developers.
it's fine. Is everyone okay with that?
Yes.
Yes. Did you get that, Nicole? To develop rather than construct.
Did I delete something?
Get rid of the
Construct
construct.
develop.
Okay, there it is.
Yeah.
That's what, okay, thank you, sorry. Where did I go wrong?
We'll just
We
backspace on construct.
and we took out approximately,
To
Yeah, we got
construct
To
approximately.
develop.
Yes.
No,
No.
To
develop instead of
Sorry.
construct.
And it's develop approximately.
And take the little d out in front of denunzio.
We need approximately.
Thank you, Mr. Johnson.
And you need the approximately, yeah. Word count,
73.
okay?
So that's one change, and what I'm going to suggest for the explanatory statement is that once everyone is comfortable with what is stated on the screen, then a council member should make a motion to amend the explanatory statement to read as follows, and then read it verbatim, what's on the screen. Once we get to that point. The next change, though, here in the explanatory statement, and of course, coming back to the topic we discussed earlier, is multifamily housing versus apartments. That change is reflected on the screen, but of course is part of the amendment. And then I know of great importance to the developer is the reference to 158 Key Hotel and what language council is comfortable with in terms of the approximation.
Ms. Skoll, come on up to the mic. What else?
My other question is not related to this.
Okay,
We are fine with, except I would add a comma after the word restaurants.
yes,
But I do have another.
okay. So any questions about this? Is everyone comfortable with this language? Do I have somebody who wants to make the motion or read?
So I make a motion to amend explanatory statement to read as follows. Shall the Clearwater City Charter be amended to allow the city, instead of selling the vacant city hall and the portion of the former Harborview sites to the highest bidder at a public auction, to sell the properties to Gotham Property Acquisitions and the Denuzio Group to develop approximately 600 apartments and 158 Key Hotel. Retail, restaurants, and cultural use is available to all Clearwater residents as further described and limited by the City Ordinance 9597-22.
Just a minor point of order, I believe the council member should have just mentioned the word "a" before the word 158 keys. If we have the freedom of the word, I would add that there.
Oh, I didn't even realize it.
I get paid to listen.
I guess it just didn't sound right, and,
Does
okay.
she have to read it again?
No, I actually read it as a,
Because she said it out loud,
All
I
right.
just wanted to make sure that what Ms. Sprague writes down conforms perfectly to.
All right, so I have a question.
Yes, council member.
If we put A there, are we gonna have to put another approximately? Because the way I read it, approximately 600 apartments and 158 Key Hotel, that's kind of, you're saying approximately that as well. If you put A in front of it,
I also believe that, I agree, Councilmember Albritton. I also believe you use the word "the" in front of the city ordinance 9597.
by city ordinance, okay. So you want me to read it again?
Without the
take the
A
A
and
out.
without the "the."
Okay.
Thank you.
So,
So is that motion withdrawn, just from a parliamentary
Yes.
Go ahead.
Okay, so I make a motion to amend explanatory statement to read as follows. Shall the Clearwater City Charter be amended to allow the city, instead of selling the vacant city hall and a portion of the former Harborview sites to the highest bidder at a public auction, to sell properties to Gotham Property Acquisitions and the Denuzio Group to develop approximately 600 apartments and 158 key hotel, retail, restaurants, and cultural uses available to all Clearwater residents as further described and limited by City Ordinance 9597-22.
Just one thing I did not hear there, I'm so sorry, but after the word "sell" is the word "the." I did not catch that, and it's okay, you don't have to reread it, but it may have been that it was stated, I just didn't hear it.
She did.
So. That's okay, that's okay. What I would suggest is a council member could make a motion to amend the main motion to add the word "the" after the word "sell."
Have a second on this motion yet?
Oh, well, okay, well, then we'll wait until there's a second on the motion.
All right, so I make a motion to amend,
Ms. Brake pointed out that that technically someone should.
You need to second her motion,
okay,
We'll have
and then we'll amend her motion to add the "the."
okay, I second it.
And then if someone would like to make a motion to.
You made the motion, so if you'll make a motion to amend it to add "the,"
So I make a motion to amend to add the word "the."
and does the seconder
Second.
approve the amendment? Okay, so I have a motion, a second, an amendment, a second. Any questions? All in favor? Aye. Opposed? Unanimous.
Doesn't this make everyone want to go to law school?
No.
Boy, I hope November 8th isn't like this.
Thank you, Mr. Mayor, and I will apologize in advance to Mr. Margolis, because as I was sitting there, I had an aha moment that I hadn't asked him about, as we've talked about this ordinance the past week. But I wanted to ensure in Section A of the Charter Amendment that the amendment allows for the council to both, and forgive me procedurally, but declare this property surplus and convey. Right now, the way it's drafted, we're simply negotiating to enter into these agreements, and I want to ensure that the declaration of surplus that will be required and the conveyance of the property is also authorized by the charter. And I want to be crystal clear and not necessarily rely upon reading several versions of the charter. So the way it's drafted, and it says that notwithstanding anything else in the charter, these two things are authorized. So I would ask if you would oblige to perhaps allow for the declaration of charter and the conveyance in the same first sentence.
I mean, personally, I'm comfortable with the way it's written. I mean, because as Ms. Cole pointed out, it does say very clearly at the beginning of subsection 8 that it is a notwithstanding and as an exception. I mean, that's strong words to anything contained in the entire section 2.01, which is literally not just the real property provisions, but extensive provisions in our charter. That said, I mean, I'm not opposed to making that change if council would like to entertain that.
And why do you not think this is strong enough?
Excuse me, it's not that it's strong, because it certainly says, the way the Clearwater Charter is in section 2.01, there are limitations on your authority.
Yes.
There's the obligation whenever the council conveys property to declare it surplus, and you're not obviated from that obligation. And there's the limitation on conveying and entering into leases specifically on the Bluff property. And so I feel strongly about adding the word conveyance, and because I think that is actually what you are doing, is authorizing the sale of this property, not just entering into the purchase and sale agreements. The declaration of surplus, I think, is covered by the notwithstanding language perhaps, but the conveyance, I would not want to get all the way down here and have a purchase agreement that the city wouldn't be able to consummate based on the lack of ability to convey. So there are several, and again, I apologize for the late ask on this. It was just as I was sitting here looking at the charter, there are several provisions in 2.01 that restrict the council with respect to this particular land that is extraordinary compared to other lands that the city owns. And so I don't want to imply that there's any restriction on the actual conveyance.
What's your pleasure? How would you add that, Mr. Margolis?
It's Ms. Cole's ask, so I would defer to her as to the verbiage that she's requesting.
You know where we're at, Ms. Sprague? On the bottom of page 2.
Hers is different. She had the notwithstanding.
So we'd add conveyance to
There it is.
Yeah.
like 3?
Under section A,
Negotiate.
that is starting with negotiate, you could start with declare surplus, comma, negotiate, comma.
And convey.
Delete and enter into development agreements and with, comma, and convey.
With comma and convey.
Well, development, enter into purchase and development agreements with Gotham Property Tenenzio Group or their affiliated entities for the purpose of redeveloping 2 properties in the downtown core, comma, and convey such properties, comma, said properties being more particularly described.
So here.
Yes, and
Convey. Said property. Just and convey.
does that make sense, David?
Although I'm generally okay with this, I mean, I think minimally, I would respectfully suggest that declaration of surplus should not state there. So as Ms. Cole pointed out, the subsection 8 here makes it clear that we are replacing the surplus mechanisms with a new mechanism, and I fear that including the phrase declaration of surplus may give the very wrong impression to voters as to what we're actually doing and why we're doing it. So while I don't have any objection to the rest of it, I would recommend to council that the phrase declare surplus should not be placed here.
Okay.
I agree.
I'm okay with that.
Okay,
Negotiate, enter into.
so go ahead and,
Just start with the capital N.
you're going to delete that.
So this started with negotiate, right? That was the first one?
It was
Yes.
negotiate and enter into purchase and development agreements with Gotham Property Acquisitions LLC. So what are we're at negotiate and, no, you need to speak it out slowly for her to have.
Oh, she did it.
It's, yes.
Okay.
But then at the end, and convey said
Oh, yeah.
properties is.
Mm-hmm. It's correct now.
Yes.
Okay.
Do you want an and after negotiate? No?
No, because you're doing 3 things,
Okay.
negotiating, entering into the agreements, and conveying.
Okay.
It- Yeah, got it.
Are you okay? Okay, do I have a motion to amend Section 8, subsection A?
Make a motion to edit, is that 8?
Section 8A.
Section 8, subsection A.
And do you want him to read Section A, please?
I think the one behind you is really, that's what the one I'm using.
She enlarged it.
Okay, negotiate enter into purchase and development agreements with Gotham Property Acquisitions LLC, the D'Annunzio Group LLC, or their affiliated entities for the purpose of redeveloping 2 properties in the downtown core and convey said properties being more particularly described as follows.
And that's it.
Second.
Any questions or comments? Did you have something else to add?
I do. Mr. Johnson just raised an issue that I will share as well. And he expressed, based on the current charter prohibition to sell this particular property outside of any process, he raised in the referendum question the issue that we're saying, instead of selling at public auction, which applies to all conveyances, the charter actually has an express prohibition that even this property wouldn't go through that process. So that's what I know.
Yeah, sorry.
You've looked at that a lot, and that's why I'm most concerned with convey, but Mr. Johnson can speak on
Are you
his own behalf.
comfortable with what we put?
Yeah.
I am.
There.
Okay. All right, I have a motion and a second. All in favor?
Aye.
Opposed? Unanimous. Anything else you have, Mr. Margolis? That's all the
No.
changes.
Those are the only changes that I have at this point. That's all I got.
Do we need to approve the overall item now?
So now that all the changes are in, we have now made material changes the council has approved, which is fine. That's what the whole point of a public discussion is, to make those changes that council is comfortable with, especially knowing how important this is to voters and to the future of the city. So at this point, I would suggest that a council member make a motion to reset and re-advertise ordinance number 97-22. Thank you, 9597-22, for a new first reading to be heard on July 21st of this year. And that will give the direction to, but we're still going to re-advertise for the second.
Yes.
So,
July, what date?
21st.
July 21st. So that way we dispose of the issue that's pending before council right now, because since material changes have been made, I think the safest thing to do for everyone and for voters and everyone to have time to digest this is to have just a brand-new first reading with the revised version that council has approved tonight. And that revised first reading will take place on July 21st. So if there's a motion to reset.
Do we have to refer to this as the amended ordinance?
That would be fine. I think everyone's going to understand. So simply reset ordinance 9597-22 as amended this evening.
As amended, okay.
To a new first reading on July 21st, and to advertise in the manner required by Florida law.
Do I have a motion to that effect?
Yes.
Can it just be moved? Or just ditto?
So moved.
Second.
Any other questions or comments? All in favor?
Aye.
Opposed? Unanimous. Anything else, Mr. Margolis?
I believe that covers it. I just want to make sure Ms. Sprague is comfortable with where we're at in terms of making sure we document everything and to make sure that before the meeting is adjourned, that everyone's on the same page.
I think so.
Anything else, Mr. Jennings?
Not for me.
Any comments from council? All right, seeing none, thank you. I know this was difficult. I have no idea what you filmed. I mean, that was riveting. So with that, we are adjourned.